Yeah, I did the wrong thing. So there it is. It says meeting is being live streamed. And I can say got it instead of hitting the X.
Yeah.
So I'll say got it. There.
Yes. There we go. All right, we are back on the record this morning. Our first case for argument, State versus Clardy. Mr. Springman is here on behalf of appellant. Ms. Gieske is here on behalf of appellee. Mr. Springman, you will have 15 minutes to argue. Would you like to reserve any of that time this morning?
Yeah, but please, the court, I'll reserve just 3 minutes.
All right, and whenever you're ready, you may begin.
All right, may it please the court, there really is one issue, and the reason we appealed this is there was a lot of confusion in our trial courts when this decision was rendered, only because of the notice and the fact the defendant was on probation, signed the rules of probation, which is admitted in this record as Exhibit C. And in there, the defendant acknowledged that a probation officer, if having reasonable grounds to believe that the probationer was not following the terms and conditions of parole, that they were put on notice that the probationer could search a vehicle or residence at any time. And the reason we brought the appeal is there is a case in the Ohio Supreme Court, as this court is aware of, State versus Campbell, where that district held that is not sufficient notification, that a person who's on probation can be searched with reasonable cause, home, it's giving consent to search to the probation officer of their home, car, and so on. So that case that the Supreme Court accepted and was argued in October, and I keep checking, and I checked again this morning, and they haven't issued a decision on it. That case, I will say, goes against the greater weight of authority throughout the state. And it also conflicts with the holdings from this court. But the trial judge recognized that and did say that the issue is before the Supreme Court in her ruling. So that's primarily why we have appealed this to make sure we don't have to change our entire procedure and process when somebody is put on probation. If we have to, and the Supreme Court tells us to, we will, but that wasn't the law in the district at the time this case was decided. So that's really the main reason we appealed. I would submit, we think there's reasonable grounds here for the stop. Clearly, I understand the trial judge's position on the tint window. It didn't go in our favor. The trial judge had problems with that. I understand that. That's the province of the trial court. The trial judge had also some concerns with that there was reasonable grounds that the defendant was dealing drugs out of 6661 Montgomery Avenue. We understand that. We're stuck with that. We get that. And but one thing that I think there is a decent argument that there was reasonable grounds to search this offender's vehicle was the fact that he did mislead probation. And that's really unrefuted and not addressed in a trial court's opinion, because he did not put down that he resided at 6661 Montgomery Avenue. And that's
Mr. Springman. Springman.
Yes.
The information that you have from the Duke Energy subpoena and the briefcase with the papers in it and everything else, that was found after the search. So my question for you is, what information is on the record that you had that he lived there before the search?
Just the testimony that was given by probation officer Chad.
Can you be more specific?
There is in here, there was an exhibit attached, and I should have put this in better order, that demonstrated that was the only address that he had provided to probation. And
I understand that. I understand that the address he provided was the Kennedy Road address.
Yes, that's it. Right.
So my question for you is, what information is on the record that showed that he was residing at the Montgomery Road address before the search?
It's just, I think on page 208 to 213 in that vicinity, it's probation officer Chad just testified to it. That's it. That's what we have.
Thank you.
Yeah, that's it. I can get you the exact
I
page.
think just for clarity, Attorney Springman, are you, because if I recall correctly, doesn't the record establish that there was an observation of the defendant coming to the Montgomery address and using the keys? And that observation was
Yes.
made before. Is that the testimony that you're referring to?
Yeah, surveillance testimony. And I'm sorry, it's 111 to 112. I was saying 200s. It's from 111 to 114 is the primary testimony from the probation officer regarding the drug trafficking and the misstating the address that he resided at. So that's all we have is pretty much right there. That's the strength of it, right? And so that's our strongest argument on that point. But again, I understand the trial court's findings, and I don't know if I made it crystal clear in the brief, but our main reason that we needed, I thought, to file this appeal was to get clarity for our trial judges in these probation matters, because it's going to, as the court knows, this would change dramatically if we are now going to be dealing with a whole brand new situation. And there's going to be a ruling, which should come from the Supreme Court here relatively soon, that now trial judges have to, during any kind of plea colloquy or at sentencing, before sentencing somebody to probation, they are going to have to verbally notify a probationer that their constitutional rights are going to be limited, and that a probation officer, based upon reasonable grounds, is going to have the authority to go in and conduct consent searches of the home and the car. And that's really the important crux of this.
You said, I'm sorry. Go ahead, Mr. Springman.
No, that's the crux of our appeal. I'm sorry, I'm done. I just, wanted the court to understand that.
Are you suggesting that we should hold this decision until the Supreme Court decides?
I would hope so. I think you could probably make a decision on the reasonable grounds determinations and so on now, but I would really ask the court to do that. And it would just, for judicial economy, I would never speculate on how the Supreme Court's going to rule. I did watch the oral argument. I'm not going to predict how that's going to come down. So, if the court waits, the only thing is right now, Geese is the law, if I'm pronouncing it correctly. And we don't have to provide verbal notification at sentencing. And
let me ask you this question. One of your arguments is that the trial court improperly considered that argument to begin with because it hadn't been raised by the defendant, and
Right.
She sua sponte raised it. The state didn't have an opportunity to respond. It almost sounds like you're stipulating at this point that you think that is a decidable issue by this court. In other words, if we agreed with your argument that the court didn't have the ability to decide that to begin with, what do we do then?
Well, I thought about that further, and originally on this brief, I understand that, the court was going through COVID protocols, and so some of the burden of productions and the burden of proof was kind of mixed up in this case, but it really wasn't prejudicial, honestly, to either party. Well, this particular issue, really we weren't put on notice by it, but were we prejudiced because we weren't put on notice by it? And we're not. And I was just trying to say, well, perhaps a better avenue for this case could be a do-over, because things weren't really done correctly procedurally. But at the end of the day, when I look at it again, to be really honest, that kind of does undercut what I was trying to get this court's attention to. And that's the issue of notice, which is really important.
And that's why I asked you that question, question because
Yeah.
it is a little contradictory to the arguments
It
that you made
is.
in the brief.
You're right.
Okay.
You're right. But I was trying to make that as an overall, try to get the court maybe to have a remanded for a do-over of the whole hearing. But, the more when you look at these sometimes a second time and preparing for argument, that really is why we appealed. I mean, how many times have I come before the court and argue that we have to accept the findings of the trial judge? Well, findings weren't really for us. And so I'm not really trying to argue otherwise. I'm just trying to say this is the reason for the appeal. And I think it's a good reason, very good reason, because it could really alter how we handle procedurally probation violations. And second, I think we need some clarity for our trial judges because, they're not operating under this ruling. And, at least they're not yet. I think they're waiting to see ultimately what the Supreme Court decides. And that's why I'm hoping this court holds it in abeyance.
And I hate to ask you a kind of a picky follow-up question.
That's all right.
But would you agree that when we get the merits of the decision, whether we hold it in abeyance, whether we decide it now, whatever we decide to do, is it fair to say that the state is conceding or abandoning its argument that the court should not have considered this issue?
Yes, I think that the court did consider it, and I just don't think there was any prejudice that we weren't put on notice by it because we were able to make our argument, weren't we? I mean, we were able to say it's in Exhibit C that he did sign the rules of probation. He was put on notice of those rules in accordance with the well-established law in this jurisdiction. How are we prejudiced by that? I mean, we really weren't, so my attempt to try to get this a whole do-over on the motion to suppress so we can get the procedural things right. I think it did hamper, it shouldn't have, but I think our trial prosecutors, they were cross-examining witnesses and they really had an opening to cross-examine and really develop that reasonable grounds. I get that, especially since they were in that position where they could cross-examine witnesses and they shouldn't have been because this was a warrantless search. We should have been asking direct questions of the witnesses. But I think that got a little confusing. And so there, all that information about that you might have seen in the pleadings about Pucci and the anonymous, none of that's in the record of the motion to suppress. So it is what it is. I hate that cliche. But again, I think I'm hoping the court understands, despite that probably not wise decision to put in the Xenia versus Wallace argument, we really do need clarity on that issue. And that's why we're appealing. It's no more than that,
All right.
There
And
goes
you are, and you are at your time if you want to reserve 3.
Sure, I will. Thank you.
All right. Ms. Gieske, you've got 15 minutes.
Thank you, Judge. May it please the court, Mr. Springman. I do agree with Mr. Springman that there's a really narrow issue that this court has to decide or hold, and that is how much notice is required under the statute. We would have no problem with holding for Campbell. Mr. Clardy's not incarcerated, so other than this hanging over his head, there's no real burden on him for you to hold it and wait to see what the Supremes do. Really, it's not. Where I disagree with Mr. Springman is it wouldn't, if Campbell is affirmed, it wouldn't change that much what trial courts have to do. There's no verbal component. It's the written notice. The statute requires written notice of these particular things. That's how these type of probation searches do pass constitutional muster, is the written notice component. So really, if you see that,
Except I think the state would argue that there is written notice now, not by the court, but by the probation. You're saying if Campbell decides it the way you think it might be decided, the court will have to actually give the notice.
No, Your Honor, I think that, well, maybe, but I think the real crux of the issue is that page where whatever the probation rules, how much detail The statute subsection A is a big section. I don't think you'll have to track it completely, but the rules now were squeezed into one page. I think that was the goal with the tiny type. And really all they have to stick in there is the warrantless searches, because this is what you have to decide, is referring over to the statute enough? That's what the current rule does. It refers the probationer to the statute and says you're subject to searches under the statute. It doesn't say warrantless, and it doesn't say the most important part, the reasonable suspicion standard. That's the standard that after House Bill 4, which the Campbell Court, the fifth district goes through, House Bill 4 really did give heightened protections to probationers and parolees. So even though they have less of an expectation of privacy, they still have it. And the way that you pass constitutional muster is to make the requisite statutory notice. So that's what this all really comes down to, is what language has to be given to the probationer. I would say it's written's more important than what the trial court says. So the rules that are handed over in this case, was that shortened version enough? That's what this case really comes down to.
And signed by the probationer. You're
right, in open court, filed of record.
Writing and yeah.
Yes. So we can see that he did sign it. It was filed into the record. All those elements are met. It just comes down to, was that notice sufficient? And we would say no. And we agree, of course, with the reasoning of the Campbell Court. Geis, that's how we say it in our office. It was my colleague's case. I don't know if that's right. Geis is a little bit different. Geis had to do, it was the same officer, but there was a warrant in that case he did go in on. And then the crux of Geis was the good faith exception and plain view. So Geis is not exactly controlling. I think the Campbell case will be more controlling. There is an aspect of Campbell that's not relevant. It was a cell phone search. So I think 2 of the 3 states' props of law, if they turn, they don't apply to this case, but the first prop of law does. So Geis, I anticipate, I don't know if it'll be out soon. The court's kind of fractured now. It was argued back in October, but there's no saying. We just don't know. Again, we wouldn't mind if the court held for Campbell. I think that would be wise. And as far as Judge Bach, your question about what evidence in the record was there that he resided at the Montgomery Road address, I did write that down. It was the anonymous tip, the fact that his car was there the day before, and then the fact that he went there that day and went in the front door with the key. So that's all they had. So if you look at just that snapshot, Fletcher out of the 6th talking about the 4th Amendment says we have to look at the stuff before the search and it has to be objectively reasonable. So were those facts alone, anonymous tip, car there one day before, car there day of, entering the house, is that enough to give rise to reasonable articulable suspicion? And we would say no, not of criminality. That's a hunch. That's lower than RAS. That's not enough. So if we do get to the merits, we would argue that this reasonable standard was not met.
So, Ms. Geisky, so the Smith case, State v. Smith, which I think you cited in your brief, this court said that for an anonymous tip to effectively provide police with reasonable suspicion to justify a stop and frisk. Now, this wasn't a probationer, but it was a stop and a frisk. The tip must not only contain detailed facts, but also predict future activities or provide means to test the informant's credibility. Can you address that in this situation? I mean, did this tip or did any of the circumstances provide any sort of corroboration or test the credibility?
So the trial court's decision went into that a little bit. The testimony, I reviewed the testimony from the suppression hearing. And yes, as you know, anonymous tips in general are disfavored. There has to be some kind of corroboration. And then the Smith case says that that corroboration is that future predictability. And we don't have that in this case. The most we have in the record is the affidavit accompanying something I believe that the officer filed. This stuff about Pucci and the anonymous person coming up, the greater detail wasn't actually elicited at the suppression hearing. I think there was some references to it in an affidavit attached to a filing. And the trial court did talk about that in a footnote. And that's the most we have. So the trial court's like, look, this was actually kind of raised, but then you didn't elicit actual testimony on it. So there's no corroboration. Mm-hmm. So that's all I really had. If there's no other questions, we have no problem with holding the case, and it really is a narrow issue. I agree with counsel on that.
Any other questions from the panel for Ms. Geeske? Mr. Springman, you have 3 minutes remaining.
Please, Cora, I don't think we're too far apart in our view of this case. We're just kind of getting guidance from Campbell. I recognize the limitations of some of the evidence that support or the reasonable grounds regarding the dealing with drugs out of Montgomery Avenue. It was there, as you can see from the pleadings, there was more there that just wasn't elicited in the record. So, that isn't the basis of the appeal, really. It's really that notice requirement. And again, I would point out, I maybe it's my German, or I know somebody that spells their name Gies, so they go by Geist. So Gies, it could be Geist too, but I think that does, I think, the reason that case is definitely distinguishable is we can't raise good faith exception to the exclusionary rule because there was an arrest warrant in that case, and we don't have that here. But that case still stands for the fact that what comprised Exhibit C is sufficient written notification allowing a probationer or probation officer to conduct these consent searches. And the way it was done in this case is the way it's done in all the cases. It may be wrong, but that's the way it is, and that's the law in this district right now, and it may change. So again, if the court would be inclined just to wait to see what Campbell says, that would probably be very helpful. And that's all we're kind of looking for is guidance, and so we can follow whatever Campbell says we have to do, because it could be a big change. But that's all I have. So, sorry, I
Any
hit the wrong button.
other questions for Mr. Springman? Thank you both for your arguments today. We will take this case under submission, and we will let you know whether we're going to hold it or whether we'll go ahead and decide it. But one way or the other, you will get a timely written opinion.
Thank you,
All
Your
right,
Honors.
Thanks.
Thank you both.
Thank you.
And Ms. Hayden, if you can bring our next litigants into the courtroom. Good morning. The next case on our docket this morning to be argued is Scroggs versus City of Cincinnati. Mr. Tidd is here on behalf of appellant. Ms. Rieger is here on behalf of appellee. Mr. Tidd, you will have 15 minutes to argue this morning. Would you like to reserve any of that time?
Yes, could I please reserve 3 minutes?
Yes, and whenever you're ready, you may begin.
Good morning. May it please the court. Kevin Tidd on behalf of the City of Cincinnati. This is a straightforward immunity case. The trial court erred when it held immunity doesn't apply to negligence claims and that the city is not entitled to immunity in this case. The Supreme Court of Ohio has explicitly held that RC Chapter 2744 establishes tort immunity as a defense to negligence claims. And immunity is the most common defense to negligence claims the City of Cincinnati uses and most political municipalities around the state of Ohio. It's a common defense that this court sees monthly, if not weekly. The trial court also erred when it found that the city was not entitled to immunity because the maintenance of trees in the tree lawn is a governmental function under both C1A and C2E of 2744, and no exceptions apply in this case.
Mr. Tidd,
Mhm.
is there any evidence on the record saying who owned the land that the tree had been on?
So there's not, but it is the tree lawn. So that is the city's right of way. So it is owned by the city. While this court has not explicitly made the finding that every appellate district in Ohio that has reviewed the issue, including the 5th, 8th, and 9th districts, have found that the maintenance of trees in the tree lawns is governmental function. Ms. Scroggs' argument that the removal of tree stumps in the tree lawn is not a governmental function is creative, but it's wrong. It's unsupported by Ohio law, and she cites no authority to support her argument. While tree stump removal is obviously the final step of tree removal because it's a portion of the tree trunk, even if it is considered a separate process, the city would still be entitled to immunity because tree stump removal is clearly an act of tree maintenance. It's irrelevant here that the Parks Department sometimes uses a contractor to grind the stump tree removal. Here, the city did not use a contractor because the tree itself was uprooted during a storm. So everything was taken care of by city employees. But regardless, political subdivisions can use independent contractors to perform governmental functions without transforming that activity into proprietary functions. None of the exceptions found in Chapter 2744 apply in this case. There's no merit to Ms. Scroggs' argument that the roadway exception to immunity is applicable here. The roadway exception relates to the failure to keep public roads in repair. Now, on its face, it's clear that this exception only applies to public roads. Public roads are defined as public roads, highways, streets, avenues, alleys, and bridges, not the tree lawn. And it's undisputed that Ms. Scroggs' injury occurred on the tree lawn. Both the Supreme Court and this court have recently declined to extend this exception to include shoulders and curbs. The tree lawn is a step removed from even shoulders and curbs. Because the city was engaged in a governmental function and no exception applies, the city respectfully requests this court to reverse the trial court's decision and find that the city is immune from Ms. Scroggs' claims. And unless you have any other questions, I think I'm done on my initial argument.
I do have one
Right.
question, Attorney Tidd. You characterize the tree lawn as the city's right of way.
Mhm.
Can you please share with us where in the record you would point to in order to support that?
So it's the way the complaint was drafted. So it was later stipulated in the plaintiff's complaint. It says I believe it says the grassy area between the sidewalk and the street. And it was stipulated that the fall was on the tree lawn, which is commonly understood as the grassy area between the sidewalk and the road.
All right, thank you.
Thank you.
Any other questions for Mr. Tidd? Mr. Tidd, in a minute, I'll calculate how much time you have remaining and let you know when it's your time for argument.
Thank you.
Ms. Reeker, you have 15 minutes.
Good morning. May it please the court. We're here today to discuss an interesting case that this court has not ruled on. My client was exiting her car and stepped into the grassy area between the sidewalk and the street and fell into a large hole. The city had been out about 2 weeks prior and took out a tree that had uprooted during a storm and then failed to fill in that hole. The conduct here is absolutely egregious. It was a very large hole. My client sustained significant injuries. The appellant cites to several cases, all in different districts, that discuss tree maintenance as being a governmental rather than a proprietary function. But none of the cases are on point and none of them control. They can only be seen as persuasive at best. The cases cited, mainly Lori, deal with trimming trees that are located on a tree lawn. Other cases such as Cycle in the 9th district and Newell in the 5th district that he cites to deal with a tree splitting on the side of the road. None of them deal with tree removal. None of them deal with filling a hole. So we would
Ms.
argue.
Rieger,
Point us to- Go
I'm
ahead, Judge
sorry.
Fox.
I'm going to ask you the same question that I asked Mr. Tidd. Is there anything on the record that shows that the city owned the property where the tree was located?
No, there's nothing on the record. It's just the tree lawn area and the city has acknowledged that it's their property.
Okay, thank you. So it's a public property. I mean, it's public ground. Anybody can walk on it, right?
It's owned by the city. Anybody can walk on it. Whether or not it's defined as public ground, I don't think there is a case out there that says the tree lawn is public ground, at least not that's in the 1st district or the Supreme Court of Ohio.
Okay, thank you.
You mentioned a minute ago the cases that Mr. Tidd relied on and distinguished them for us. Do you have any cases to cite us from Ohio where a court held that the tree maintenance was not a governmental function?
No, those are the only 3 cases that I've seen are Lori, Cycle, and Newell out of the 8th, 9th, and 5th. So that's, he mentioned earlier how I didn't cite any authority. It's because, as far as I know, this is a case of first impression in front of the 1st district, that there hasn't been a case that's been argued before this court as to whether or not tree removal constitutes tree maintenance. and whether or not tree maintenance constitutes maintenance of public grounds.
Thank you.
So but the main argument that I'm making before this court is that the city is not entitled immunity under the exception of Ohio Revised Code 2744.02B2, which is that they were performing a proprietary function. We disagree entirely that this is governmental. We have to look at, it's important to me, and we talk about this a bit in the citation to Alkis versus Bainbridge, which isn't on point as far as tree removal goes. But what that court discusses is distinguishing between the act that caused, the injury outside of the overall structure. So we have a city that removed a tree and failed to fill the hole. And the failure to fill the hole is what caused my plaintiff to get injured, not the actual tree removal itself. So I think that it's important to distinguish between the tree removal and the failure to fill the hole. That's the main thing here. I also presented something to the trial court about an exception under 2744.02B3, which is the public roads exception. I did see the citations in the appellant's briefing about failure at the first district not extending it to the curbside. So my main argument is about this being a proprietary function. So go ahead.
So for clarity, it sounds as if part of your argument is whether failure to fill a hole is part of tree maintenance, and then is tree maintenance, maintenance of public grounds.
Yes, it's twofold. So I'd argue that the first district should not rule that maintenance of trees is that is a governmental function. It should be proprietary. But if you do see it as governmental, there's also a second piece of this where they failed to fill that hole. They didn't do it on site. They didn't come back and take care of it. They didn't put down cones. They didn't put down boards. They warned no one. And then that hole filled with leaves and dirt and appeared to be flat ground. So my client had no idea that there was a hole there. She stepped right in it. They didn't fill the hole. And is filling that hole tree maintenance? I'd say no.
And for clarity also, was the hole created in, how can I put it, in the process of removing the tree that they dig and create the hole, or was the hole created by the falling of the tree?
I'm not sure, Your Honor. We didn't do any depositions on this case yet, so my client hasn't testified and neither has a representative of the city, but it's likely a combination of the two.
Okay, thank you.
Would your argument extend in a case, let's say that the tree maintenance was cutting down limbs instead of removing the tree? If those limbs had remained laying on the ground as a hazard, would your argument be the same, that there's a distinction between tree maintenance and failure to pick up the limbs that were cut off?
Yes, I think that would be separate. And I'd also probably be arguing that they were obstructions to the public roadway at that point too, if it was a limb issue. But tree trimming and tree maintenance of an actual existing standing tree, I think is very different than tree removal and definitely of filling the removed hole.
Thank you.
If the court has no further questions, in sum, my argument is that the biggest problem that the city has is that there's nothing on point in the first district and there aren't any controlling cases, and that their conduct was absolutely outrageous and that they left a giant hole in the tree lawn, and then failed to fill it, causing significant injury to my client. The city shouldn't be allowed to act this recklessly without being liable for this, without being punished in some way. And there's got to be a limit to what they're able to do. And I think this is it.
Attorney Rieger, I have one more question. And I know that I understood you very clearly that the record doesn't establish this, all right? If the hole was solely created by the falling of the tree, would that change your argument in any way?
No, because I still think that if the city is removing the tree and the city owns, this tree lawn area, then they had a duty to fill that hole and they did not.
Thank you.
Any other questions for Ms. Rieger? Thank you very much. Mr. Tidd, you have 11 minutes of your time remaining if you'd like to use it.
Sure, I'd first like to address the Lori case. In the cases that I cited in my brief and in my reply, I focused on the Lori, Cycle, and Newell cases because those trees involved trees in the tree lawn. And I know if I argued, hey, the city is responsible for the maintenance of the tree lawn, the plaintiff would come back and say, well, hey, this is different because there's a tree. So that's why I focused on those cases, because those were the cases that were the closest to be on point. But I do want to stress that Lori goes a little bit beyond just tree trimming. It also discusses that the tree lawn is within the ambit of a city's care. So really, it's saying the entire tree area. I'm focused on a tree here because a tree is what's before us today. But it's more than just tree. It's the entire tree lawn area. I also want to hit on something that the plaintiff talked about. It really had to do with her plaintiff's injuries. And it's really unfortunate. It's never good when somebody's hurt. But immunity is harsh. And as this court has noted several times, in its Bernard decision, in its recent Williams decision, it's up to the legislature to change that law. But this is a defense that is available to the city, and it's meant to be used early in the proceedings because the city is so often sued in so many different angles. We do a lot of discovery. There's a reason that we have this defense, and there's a reason that we're allowed to present it. Like I said, it's not always, it can be harsh, but it's still the law.
Thank you, Mr. Tidd. Any follow-up questions for Mr. Tidd? All right, thank you both very much for your arguments this morning. We will take this case under submission and give you a timely written opinion. That will conclude the arguments this morning for the First District Court.